Good evening or good afternoon or good morning, everyone, wherever you may be, and welcome to the Center for Fundamental Rights in Practice event this evening. My name is Başak Çalı. I'm a professor of international law, and I co-direct the Center for Fundamental Rights at the Hertie School. This evening's event is organized in collaboration with Human Rights Watch, and I'm delighted to have an excellent panel with me today to discuss reflections on Koblenz. This is the Crimes Against Humanity trial in relation to crimes committed in Syria, crimes against humanity committed in Syria in German courts. Now, you could be a little surprised that a trial about mass atrocities and also very serious crimes in relation to the civilian population in Syria has actually found its place in a court, in a very tiny court in a small town somewhere in Germany called Koblenz. And we will be discussing how this trial came to this court. So what has led to this Crimes Against Humanity trial to take place in Germany, and in particular in Koblenz, and why not anywhere else, for example, the International Criminal Court or in any other venue. We then will talk about what happened in the court in Koblenz once this trial has started. And then our aim is to go outside of the court to discuss the implications of this trial, this broader implications of also the verdict in Koblenz. So in order to have this discussion of how we got here, what happened in the court, and what happened after the verdict, I'm really joined by an excellent panel of speakers. I will introduce them to you very briefly. So the first speaker today is going to be Whitney-Martina Nosakhare, and she's an assistant counsel for the International Justice Program at Human Rights Watch. And she conducts research and advocacy on universal jurisdiction. And she has also been very closely monitoring the Koblenz trial. After Whitney, we will hear from Anna Oehmichen, and she's a criminal lawyer, and she's practicing criminal law since 2011. She specializes on cross-border and international and European criminal justice. And she also publishes regularly in these fields. And she also holds a lectureship at the University of Gießen in Germany. Perhaps also very significantly, she represented several victims as well as joint plaintiffs before the Koblenz trial in relation to one of the Koblenz convicted, suspects convicted. This is Anwar R. And I'm also very much delighted to have Wafa Mustafa with us today. She will be our third speaker. Wafa is an activist from Syria. She's also a journalist, and she's a survivor from detention. She left Syria in 2013 after her father was forcibly disappeared by the state authorities in Damascus. Wafa's activism and work covers the impact of detention on young girls, women, and families. So as I said, we will try to give you a broader context with our excellent panel of speakers, and then we will also open the floor for comments and discussions. We will follow this trial as to how we got here, what happened in the court, and what happened after. On that note, I'm delighted to give the floor to Whitney. Thank you, Whitney.
Thank you, Başak, and welcome to everyone listening. So as Başak said, I'm in the first contribution to this panel. I want to give you an overview of firstly, what this trial in Koblenz was about. Secondly, why it was possible for this trial to happen in Germany in the first place. And thirdly, why this trial was so significant, or maybe not, and how it ended. So 2 years ago, the first trial worldwide on Syrian state torture, crimes against humanity, started in the German city of Koblenz. 2 former Syrian intelligence officials were arrested the year before. One higher-ranking Syrian official, Anwar R, and one rather lower-ranking official, Iyad. At the time, Anwar R was accused of overseeing torture in 4,000 cases murder and sexual assault. Iyad A was accused of aiding and abetting the torture of at least 30 protesters by transporting them to a detention facility where they were tortured later on. These crimes, the German prosecution alleged at the time, took place at a very notorious prison in the city of Damascus in Syria, branch 251, also known as the Al-Khatib prison. This prison belongs to the Syrian intelligence agencies, referred to sometimes collectively as the Mukhabarat. Over the course of almost 2 years, more than 80 witnesses testified, including former detainees, former Syrian government employees, German police investigators, and experts in Syrian affairs. During these almost 2 years, we heard witness testimonies of mass graves, the existence of mass graves, on how the Syrian government systematically planned the crackdown on peaceful protesters in 2011. We heard about the brutal torture in Syrian prisons. And I want to give you, an insight on what exactly we heard witnesses say in Koblenz during this time. We heard from survivors that they were arrested sometimes during protests, blindfolded and beaten in so-called welcome parties. After they entered the detention facility, people, officials beating them with sticks and other objects, put in overcrowded cells with other people who needed medical care or were malnourished. We heard from a forensic doctor who analyzed thousands of the so-called Caesar photos, the Caesar photographs, a photographic documentation by a Syrian defector with the name Caesar, who took pictures of deceased bodies in different intelligence service facilities in Syria. So these are the broad facts, right? We have 2 individuals, 2 former Syrian intelligence officials, relatively low ranking, accused of committing crimes against humanity in Syria, on trial in Germany. Now, I said that I wanted to talk also about why this trial took place in Germany in the first place, right? That's maybe an unusual location, as Başak indicated, to try crimes that were committed years back and miles away. And let me start off by maybe saying why other avenues were actually blocked. So some of you might think or ask the question, well, why did this case not end up before the International Criminal Court in The Hague, the ICC? Syria is not a state party to the ICC, so the ICC has no jurisdiction to cover crimes that were committed on Syrian territory. Now, others might think, well, what about the United Nations? What about the United Nations Security Council? According to the Rome Statute, the statute that constitutes the court, the ICC, the United Nations Security Council can refer a certain situation to the ICC, right? Unfortunately, Russia and China have blocked these attempts several times in the past. They have vetoed these attempts. So these blockages force the international community to find other creative paths to document the atrocities in Syria. And this led, for example, to the creation of the so-called IIIM, which is a United Nations body that collects evidence and assists national prosecutions in their own investigations. And since we don't have the ICC avenue, we also don't have the United Nations Security Council avenue. States have taken it upon themselves, national authorities have taken it upon themselves to investigate and prosecute crimes committed in Syria and in some way push for accountability. And one of these countries is Germany. So coming back to the Koblenz trial in Germany, there are several factors that enabled German authorities to build this case in Koblenz. And I'm going to name a few, but they're not exhaustive, right? So the first factor is the existence of so-called universal jurisdiction laws in Germany, or in German called das Weltrechtsprinzip. So what is universal jurisdiction? The principle of universal jurisdiction refers to a framework that permits national judicial systems to investigate and prosecute certain crimes, even if they were not committed in the country's territory by one of its nationals or against one of its nationals. And Germany has so-called pure universal jurisdiction laws, which means that German authorities do not need any link to the country where the crimes were committed to actually investigate these crimes. So German authorities have the power to investigate serious international crimes very uniquely, and you will find these laws in Germany's Völkerstrafgesetzbuch, the Code of International Criminal Crimes. The second factor is the existence of evidence. German authorities started investigating international crimes in Syria in 2011, when the uprising started. And that, of course, put German authorities in a very good position to build these cases, right? For the Koblenz trial specifically, a lot of factors came into play here again. One of them, which I do want to talk about, is being that like one of the defendants, Anwar R, kind of put himself on the radar of police investigators. Anwar R, while living in Germany, at one point felt followed by the Syrian Secret Service and went to the police station in Berlin to file a criminal complaint. And while he was doing so, he gave the police investigators information about his work at branch 251 and even signed the police protocols with his former title, Colonel Anwar R. So he put himself on the radar, but of course there were also other factors that contributed to the investigation, right? So several complaints, criminal complaints by victims groups and NGOs. Talking about victim groups and NGOs, that leads me to my third and last point here, and most important point, the fact that many Syrian survivors live in Germany and other European countries, which makes them accessible to prosecutors and police investigators to interview. And for Koblenz, Syrian survivors and victims have been the cornerstone of making this happen. Without the determination and the courage of them, Koblenz would certainly have not been possible at all. Good. Just a couple of words to the significance about the Koblenz trial. So why is this trial significant, and why are we talking about it? Why are we here on a Tuesday evening talking about the Koblenz trial? Both defendants have now been convicted and sentenced to prison time. I'll talk a little bit about that later, but surely this case in Koblenz is not sufficient to say or to claim that comprehensive justice has been served. There needs to be more done to hold those accountable who committed serious crimes in Syria and are still committing serious crimes in Syria. And the value of such cases is certainly debatable, which is why we are here today. And we're going to hear a lot about that later as well. But let me tell you why I think that we need these cases. The first reason is that these trials are, for many survivors, the only chance to get their day in court and see some form of justice done. It's one chance, and maybe also the last chance, to have their truth established before a court of law, if that is important to them, if that is something that they want and that they consider to be justice. Second of all, these trials are important because they contribute to the analysis and assessment of a body of evidence that can in the future serve other courts and maybe other international tribunals, which may be established in the future, to build these cases. And lastly, I think it's important to mention that, these trials and the Koblenz trial, it sends a message and a signal that, first of all, Germany will not be a safe haven for war criminals, And secondly, very importantly, I think that the laws of international criminal law are in full effect. They are valid and they will be enforced. So how ending my contribution, for the first part, of our discussion. How did the trial end? Well, you see, the first defendant got convicted in February 2021 to 4.5 years. He got sentenced to 4.5 years for aiding and abetting crimes against humanity. And Anwar R., the more higher ranking official, got convicted for crimes against humanity as well. Just this January, and he was sentenced to life in prison. There is another trial happening in Frankfurt, Germany, right now, against Ala M., a Syrian doctor who is also accused of committing crimes against humanity in a military prison. So, the hope is that not only Germany, but other countries with these existing frameworks bolster their efforts to conduct these investigations and prosecutions. And yeah, I'm looking forward to your comments and thoughts on the trial. And thank you for your attention.
Thank you very much, Whitney. So let me just quickly turn to Anna in her also experience of representing victims and also plaintiffs in this trial. I'm also curious, we've discussed this a little earlier, but perhaps you could also tell us a bit more about why Koblenz, why not Berlin, which, for example, has a much sizable Syrian population than Koblenz. But over to you, Anna.
Well, thank you very much, and thank you also to Human Rights Watch and Hertie for this opportunity to discuss with you today the trial. Well, to answer your question briefly, the place where the trial takes place in Germany depends on the residence of the defendant, and we had here 2 defendants, one in Berlin and one in Koblenz. So the prosecutor could choose the place where he wanted to have the trial and indict. So that's the reason. And I don't know why the prosecutor chose Koblenz. Can be many reasons for that. Now to come to the topic, I was asked to talk about the report a bit about inside the trial now, and I would like to start by a few positive remarks on this trial. So what I find very good, besides the principle of universal jurisdiction already mentioned, which was facilitated and brought to life by these structural investigations that were carried out since 2011. What I found remarkable is that the Koblenz court managed to carry out these proceedings in a very speedy and efficient manner, and in a very humble manner also, and very objective and impartial way. In spite of all the restrictions due to the pandemic, they had to cope with a very difficult situation. They started in April 2020, so just when the pandemic broke out, and so in that sense, I think they did a very good job in carrying out this so quickly. Another positive aspect is that Arabic translation interpretation was provided for accredited journalists, although the civil parties had to lodge a constitutional complaint to reach that, but they managed, and then accredited journalists could listen to the whole trial in Arabic. This hasn't happened before. And another very positive aspect from the German system in general for a trial like this is that you have the possibility to participate as joint plaintiff, which you don't have in all legal systems. So a joint plaintiff, and that was what my clients were, means that they can have access to information on the case, that they can be represented by a lawyer throughout the trial, that they can participate and attend all the hearings if they want to, and ask questions also to the witnesses. They can file motions for evidence, so they can really actively participate in the trial and also give closing arguments, which some of them did, and one of my clients did too at the end. And this contributed also to make the case more real and more close, to have the people here. So now I will turn to a few shortcomings in the German system, and I will focus on the witnesses, not only joint plaintiffs, but Syrian witnesses in general. They were very vulnerable in the present case, all of them, I would say. Either they were vulnerable because they were victims of torture and ill treatment, because they had lost family members, or they were also vulnerable, some of them, because they had worked on the wrong side for the regime in Syria, and now in trial risk to incriminate themselves by testifying. So in spite of the vulnerability of all of them, not all of them were legally represented. Not all of them were well informed about their role and what they would face and what would happen to what they said and how this would be received, and that the trial was public, and that what they would say would be that there would be a public gallery and people would listen to their name even. So I think a very serious shortcoming was that the witnesses were not all well informed about this. Another problem in the German system is that you have the possibility to appoint a duty counsel to a witness if you think that witness is vulnerable. But that duty counsel for a witness, if he's not joint plaintiff, is limited to the testimony in court. So the lawyer gets only paid for the 2 hours or 3 hours of attending the court hearing and sitting next to the witness, and at the best way representing him by keeping silent and letting the witness talk. But the most important job of a witness counsel should be to tell the witness beforehand how this whole procedure will go and what kind of questions the witness can expect and how the witness should answer the questions and what the witness should do if they don't know the answer, etc. So a lot of things that are crucial to be a legal defense or legal representative of the witness are not being paid if the duty counsel doesn't get paid for that preparation. So you had also the problem that some witnesses were represented, but the lawyers didn't know anything about the case and only appeared on the very day, and were not of very much help, which was not their fault, but the fault of the system. Another problem that has been raised already by many is that there were no transcripts, because in German criminal trials we don't have transcripts. And an example of how this may have affected this trial was that the defense lawyer very often used this by asking the witness after the testimony was finished, I remember, did I understand correctly that you said, and then he repeated what he understood the witness had said, but which was not exactly what the witness had said. And sometimes it was maybe even a strategic way of misunderstanding the witness deliberately to make the witness weaker and force the witness to repeat and clarify things that actually could have been read in the transcript if there had been a transcript. And so that's a very typical example where I think the lack of the transcript is not only a problem for the defense lawyers, but it's for all the parties a problem. And another problem that also is not only limited to international crimes, but in this case, because of all the Syrian participants, was very vivid, was the problem of translation errors. There were 3 interpreters or 4 throughout the trial, but not every error was corrected. They were not always telling when mistakes were made, and sometimes mistakes can be very crucial, and it makes a big difference if you talk about the revolution or the incidents in Syria, for instance. But these were things that we learned during the trial and not things that we were prepared to know before. Maybe Wafa can elaborate on that, because I felt always incapable of judging this because I don't speak Arabic, and I wasn't able to judge whether there were mistakes. But sometimes I had the suspicion that there were mistakes because witnesses just wouldn't answer the questions. So the court would ask a question and the witness would answer something completely different. And I didn't know, was that because the witness didn't want to answer, or was it maybe because they didn't understand the question, or because the court did not, or the question wasn't translated correctly. And this made the courts the judges impatient, because they had the feeling the witness didn't want to answer and they were repeating and repeating the questions. And that made the witness angry, because the witness thought they don't want to understand what I'm saying. And maybe it was just a language problem, but we don't know. At least I don't know. And the most important or the most problematic topic that was also tackled already in publications on this trial is the problem of witness protection. And witness protection is really paramount in cases of international crimes, because in international crimes, it's often the only evidence available. If we don't have a witness, we don't have a trial. And if the witness is afraid of testifying, it won't testify and there won't be evidence. In the Koblenz trial, the case was particularly serious because the conflict is not over. So the witnesses feared not for their own lives. Many of them didn't care about their own lives after what they had gone through anymore, but they feared for their family. And if the family was in Syria or elsewhere, in neighboring countries, they knew that the family was at risk if their name would come out into the public. And this led to the fact that some witnesses, when they didn't have to, they wouldn't come to the court, they wouldn't appear. Others would come, but would change their statement completely in front of the court. In one case, this led to the prosecutor being really angry and threatening to criminally charge the guy for giving false statement. And this was a guy that, again, had no defense counsel who could advise him what he should do in such a situation. So these were problems, and of course, Germany cannot protect the family in Syria. Germany cannot go beyond Germany's borders, actually, to do protection measures. But what we could have done and what we should do in future trials much more is to inform the witnesses well beforehand, inform them well about what it means to testify, what happens to their statement, and what risks there may be also. I am just checking the time. So one problem there, or one thing of the German procedure that witnesses should have been warned about, is the principle of orality and immediacy of the criminal trial, Unmittelbarkeitsprinzip und Mündlichkeitsprinzip in German. And that means that the court will base his judgment only and exclusively on what they have heard and seen during the public trial. So whatever is in the file does not lead to the judgment unless it is being heard again in court. And this means that all the witnesses that had been interrogated before had to appear again in court and repeat their story in front of the judges. And not all of them knew that they had to do that. So it was also, they were scared when they heard that. And they would be confronted with what they said before during police. And also this was something not all of them were prepared with. So they they didn't understand why they were asking them the same questions that they had been asking them to the police, but the court did so in order to assess their reliability and credibility and see whether they were coherent. So
thank you.
So this,
yeah.
Okay, I'm coming to an end. The main thing is maybe what we can learn for future trials is with regards to witness protection, look a bit at the international tribunals and make use a bit more of protective measures that are available there and introduce them also into the German system. For instance, also provide witness support beyond the trial, not only during trial, but also before logistic, and also in some cases, if necessary, offer relocation interviews per video conference, etc. Thank you. I look forward to your questions.
Thank you. Thank you so much. I mean, one of the really striking things that you also showed us is how much was at stake for those who actually made this trial possible. And there were a lot of genuine risks for everyone who actually participated in the trial. Now, let me turn to Wafa. So this is still the month of March. So this is the 11th year of the conflict in Syria, but it's the systemic human rights violations are older than 11 years as well. So this is when we think of the age of the conflicts, but of course the human rights problems go much more deeper than that. How do you react to the significance of this trial, given that the conflict is still ongoing? There has been no transition, no transitional justice in Syria for over a decade at the moment.
Well, thank you. Let me actually start by saying that since I mean, I think in the bigger part, my daily fight is because this is this is what I can actually do, what is possible. It's partially about narrative. So I think it's important for me to say that March marks the 11th anniversary of the Syrian revolution. So the conflict, yes, obviously there is a conflict that started later, but what started in March 2011, that was the Syrian revolution, where people actually reacted and spoke up and went to the streets, daring to demand a better reality that, as you mentioned, that already has been, part of our history. I think it's let me just also say that I live in Berlin. I've been living here for the past few years. I've been obviously, I mean, as an activist, I mainly focused on the detention, enforced disappearance in Syria. So I heard about the trial, and it's important to say why I went there. I was not involved in the trial in any, I don't have any legal background. I don't work. I'm just an activist. But when I heard about the trial, my first intention was to go there. And obviously, yes, experience this moment. I didn't even know what to expect, but I think my first thought was that I wanted to go there to make sure that, somehow to capture this moment for my dad. And this is something I do in my daily life. I do things, I go to places, I take pictures, I write things in the aim that this is something like diaries that I'll keep for my dad, who today completed 3,192 days. So this is 8 years, 8 months, and 27 days. And to be clear, my dad is forcibly disappeared, which means that no phone calls, no letters, no visits, nothing. We don't even know if he's alive or not. And this is unfortunately far from an isolated case. And this is why, as a family of someone who's disappeared, to survive, I need to, just create this, not to create, actually, this lifestyle is is imposed on us. So I went to Koblenz. I protested outside the courthouse with my dad's picture, but also with photos of other people who were not only detained or kidnapped or disappeared by the Syrian regime, but also by other actors in the country, to say to save this for my dad, but also I think most importantly to say that what is happening inside the courthouse is important and is great and is a first step, a first little step. But for people like me, who are like millions in Syria, most importantly, we need urgent action to save my dad and to save those who are still inside detention centers. And, you know, I went there. I didn't expect that the trial will be a huge thing. I just went there and I sat in front of outside the courthouse. And I think the one thing that was shocking mostly to me was that the reaction of the families of those whose photos we put in outside the courthouse, because even, you know, families inside Syria reached out to us to say that that this meant a lot to them, that someone remembered their loved ones, because some of them were you know, disappeared for 10 years, and their families are so desperate to the extent that they felt so grateful that someone actually remembered their loved ones. Even they knew that it had nothing to do with the court and with the process inside. But I think this whole scene tells a lot about the reality of families of detainees in Syria. And I think, I mean, it was a huge responsibility. I still believe, I said at the beginning that I thought that the trial is very important. I hoped, to be honest, that as a Syrian, as an activist, and as a family member, I hoped that this will not change our reality, but at least push Syria's case a step forward on a political level. So I went there, I protested a couple of times outside the courthouse. I kept repeating the same message. I wanted to add, I mean, I didn't think of it like this at the beginning, but eventually I realized that the scene, the images of people, detainees outside the courthouse, added a human face to a legal process, which many Syrians did not really understand at the beginning. Not only Syrians, you know, ordinary people did not really understand the proceedings, did not really understand why is this happening here, how come, what to expect and everything. But I think, again, this is you know, this is about hope. I went to the court because I thought there is hope there. So I went there to, you know, to see if you know, if there is anything I can do, if I can, you know, engage in any form, which I did. And I thought that, and I still believe that it is really important for me, because first and foremost, it says that Assad's Syria is a torture state. And this is something, you know, this is something I've been repeating for 10 years. Millions of Syrians have been repeating for 10 years. But for the first time, you know, for obvious reasons, the world is willing to hear that and to accept it as a fact, because obviously a trusted legal system said that, yes, torture in Syria is systematic and widespread, which is a huge disappointment, because as you can imagine, this is what I've been repeating for 10 years. This is what, you know, what we're fighting for, but it happened. But it's also important for us as refugees, especially because in Germany at that time, you know, the discussion about deportation and whether Syria is safe or not was on the table. So it was very important to say that obviously you cannot send Syrians back to Syria at the same time, when you're at the same time prosecuting people for being part of a regime that you said uses detention as a weapon against its own citizens. So there are many, you know, important aspects to it. But to be honest, after the verdict, the final verdict against Anwar Rislan, I had very mixed feelings. I'm mainly disappointed because the process took 2 years, and on international and political level, nothing has changed in our reality. Nothing has changed in the reality of Syrians inside Syria. Nothing has changed for my dad, who's, if he's lucky enough to be alive after, you know, almost 9 years inside detention centers, then he must be still waiting for someone to save him. But nothing has changed. Nothing has changed for me. I still wake up every morning realizing that my dad is still somewhere between life and death, and that nothing I've done and nothing I can do and nothing I'm doing is changing that. And obviously, you know, to be honest, I believe that, or I feared, let me not, you know, give it as a fact, I fear that these trials and these processes are used politically as an alternative to a comprehensive solution to the situation in Syria, as an alternative to a comprehensive solution to the crime of detention, enforced disappearance in Syria, and most importantly, as an alternative to the failure of the international community to stop Russia, which we're seeing now, unfortunately, in Ukraine. If Russia was stopped in 2015 when it first intervened in Syria, I wish that what we're seeing today, the heartbreaking images and footages and the heartbreaking suffering that Ukrainians are going through, maybe would have not been, you know, possible. But you know, international community failed Syrians, and I really hope they don't fail Ukrainians. But this is what we said. If you allow Assad and other war criminals to get away with their crimes, that sends a clear message to all war criminals around the world that yes, you can kill your own people, you can bomb them, you can use chemical weapons against them, and you will still be called a president, and you will still, you know, now we're talking about normalization of relationships. We're talking about Denmark with the zero refugees policy. So this is, you know, when you see the celebration of the trial in the media and that justice has been served and everything, and as a Syrian, you know, you hear about Denmark, you hear about detainees, you hear about Caesar photos, and you talk to people in Syria and you see that the reality is just getting worse, then to be honest, it's a bit difficult, you know, to participate in this celebration, and it's a bit difficult to feel very optimistic about these trials. I still believe they are very important, they are needed. Obviously, they're the only path we have now, but a lot is needed, and we need to do a lot more.
Thank you very, very much, Wafa. Also reminding, I mean, I think the balance that you presented us between that it is significant, but also this really important doubt that maybe, you know, the celebratory tone on these trials might actually be also masking things that are not being carried out at the political level. Thank you very much for the intervention.